Hello, St. Mary's. First, I would like to thank you for allowing me to address you today and sharing with you in honor of Black History Month. As a young girl, I wanted to make a difference in the world, and I knew I wanted to do so by practicing law. Even though I knew no attorneys, and neither of my parents graduated from high school, my goal was to attend an Ivy League school, become a lawyer, and maybe one day run for public office. So to that end, I worked and studied hard in high school, graduating as valedictorian. Dreams do come true. I went to Dartmouth College, graduated from law school, and went on to practice law for two major law firms here in the city. Served as a corporate attorney for Regional One for close to a decade, and practiced as a sole practitioner with my own private clients. Sure, I have impacted lives in these positions. Sure, I have provided good counsel to my clients. Sure, I have helped corporations with their bottom lines, to implement good policies and procedures, and to be good community partners. But was this enough? Was this enough? Always in the back of my mind, always still in my heart, I've always had this burn to make a real difference through the practice of law. Then this happened. On May 25th, 2020, in Minneapolis, Minnesota, George Floyd was killed by a police officer during an arrest when an officer knelt on Mr. Floyd's neck for 8 minutes and 46 seconds. As you and I and the whole country watched in horror, the reality of police misconduct, disparate treatment of minorities, and the need for legal justice reform came to the forefront of America. Like many of you, I felt helpless. But more than that, as a member of a minority race and as an attorney, and as a past president and current board member of the Ben F. Jones chapter of the National Bar Association, I felt compelled to do something. And for those of you who don't know, the National Bar Association is mostly comprised of African American attorneys, and the Ben F. Jones chapter is the chapter here in Memphis. Again, I felt compelled to do something. I approached our board and president and suggested that we form a legal justice task force because to me, there was an obvious need to address criminal justice and seek reform. Hence, the birth of the National Bar Association's Legal Justice Task Force, with me appointed as chair. At one of the first meetings of this task force, it was suggested by a good friend of mine, Kimkia Harris, who later became co-chair of the task force, that we take up the cause of Purvis Payne. My immediate question was, why should this task force get involved in the case of someone on death row for the brutal murder of a mother and her young daughter? Without going into too much detail, because I could talk for hours about this case, here are some of the simple details. In 1987, Sharice Christopher and her 2-year-old daughter and 3-year-old son were stabbed by someone while they were in their apartment. Sharice Christopher, who was stabbed over 40 times, and her daughter both died from their injuries, and her son was badly injured. Purvis Payne, soaked in blood, was caught by the police as he was running from her apartment. This should be an easy case, right? And with these facts, it did prove to be a win for the prosecution, and Mr. Payne was sentenced to death. But on closer inspection, there were a myriad of issues that deserved the attention of this legal justice task force and why we took up his cause. According to Mr. Payne, this is what happened. Purvis Payne had planned to spend the weekend with his girlfriend, who lived across from the victim, Sharice Christopher. He was waiting for his girlfriend to come home and let him into the apartment when across the hall he heard screams and moans for help. He went to the apartment and then found a horrific scene. Sharice Christopher and her daughter stabbed and bleeding to death. There was a knife stuck in her throat, and he tried to move it and assist her. When he heard police sirens in the distance, he realized the gravity of his circumstances. He figured the police would think he was the perpetrator, and he ran. According to Purvis Payne, in his own words, I saw the worst thing I ever saw in my life, and like my breath just had taken, she was looking at me. So again, why would this legal justice task force want to be involved? Why? Notwithstanding that some would argue that Mr. Payne never received a fair trial because the prosecution played to racist themes and withheld exculpatory evidence, there were significant legal issues in this case. In 2002, in the case of Atkins versus Virginia, the U.S. Supreme Court ruled that executing people with intellectual disability violates the Eighth Amendment ban on cruel and unusual punishment. The court explained that persons with intellectual disability are at a special risk for wrongful execution and recognized that intellectually disabled defendants are often unable to assist their lawyers and make poor witnesses. These concerns played out in Payne's case. So even though it is current law that you cannot execute someone with an intellectual disability, because Purvis Payne was convicted prior to this ruling in 2002, he cannot receive the benefit of the U.S. Supreme Court ruling and current law. The Tennessee Supreme Court even acknowledged that Payne presented undisputed evidence of intellectual disability and that the state has no interest in executing a person with intellectual disability, but they concluded that they had no procedural mechanism, none existed for Payne to present his case. While many other states have passed laws consistent with this Supreme Court ruling, Tennessee has not. Thus, his execution, though unconstitutional, is still perfectly legal. Some other reasons we took up the case of Mr. Payne were, although prosecutors argued that he was high on drugs and alcohol, he had no history of substance abuse, no drugs or alcohol screen were done on him, and his family begged that he be tested to prove his innocence. He also had no motive, no criminal history, had never been in trouble. DNA testing was also one of the main reasons that we became involved in the case of Mr. Payne. In this case, there were more than a dozen items of evidence that had never been tested for DNA. At the time of Mr. Payne's trial, more than 30 years ago, DNA testing did not exist as it does now. In particular, the murder weapon, a knife, had never been tested for DNA. If the presence of another person's DNA could be found on the murder weapon, in particular, it could provide sufficient evidence to exonerate Mr. Payne at trial. It was our position that if someone's life is at stake and DNA testing is available, you should always test the DNA. One fact to note, shockingly, some of the most significant pieces of evidence in this case, including fingernail scrapings and the victim's clothing that should contain the DNA of the true perpetrator, are mysteriously missing. So, we don't know the guilt or innocence of Mr. Payne, and I'm not here to vouch for his innocence, but what we do believe is that he deserves clemency from a death sentence. So, what happened? After the task force got involved, we held a press conference. We were able to mobilize a powerful coalition of legal, legislative, faith, and community organizations and other allies to its cause, including the Tennessee Black Caucus of State Legislators, the Memphis Bar Association, Stand for Children, Memphis International Coalition for Action and Hope, Church of God in Christ, and Bend the Art. Since our involvement, his case has had a significant social media presence, numerous local and regional television features, and even national news such as CNN. We petitioned the governor for clemency. We have been partially successful. The court ruled in our favor, allowing the DNA to be tested. The governor stayed his original execution date, which was set for December 3rd, and it has been stayed until April 5th, and it has not been reset for execution. And most significant, one of the first bills of this current session that was introduced into the Tennessee House of Representatives was a bill to address Tennessee law to make it consistent with the 2002 Supreme Court ruling that the state cannot execute individuals with intellectual disabilities. Coming full circle from where I initially started this talk, I wanted my law degree to make a difference, right? I believe this is what we have done in the case of Mr. Purvis Payne. I also had the pleasure of working on Capitol Hill and serving as Chief of Staff for Congressman Harold Ford Sr. and Jr. One day, while attending a function after work, the Congressman and I picked up the late Congressman John Lewis. What I remember about him was that he was so gracious and so inspirational. To quote John Lewis, "Nothing can stop the power of a committed and determined people to make a difference in our society." You all are wonderfully bright, smart girls, and you will do well in your chosen fields. But along the way, make a difference in someone else's life. While you seek to make your mark in life, seek to make your mark on mankind. Do not live your life so insular that you only focus on self and not the betterment of others. That's my message for you today, girls. Go forth, be great, and have a wonderful day.